House Judiciary Committee Chairman Jim Jordan subpoenaed Thomas Windham. Oh, I can't talk about it. My boss has said I can't. Congress like, oh, all right, guess this hearing's over. But that was not a matter before a grand jury as the rule requires. That was a fake committee. You now have a subpoena.
Instead, it's a setup. It was all to undermine President Trump and his presidency.
A top Jack Smith prosecutor now gets a subpoena. We got a lot of questions for this guy, Thomas Windham. We've read through many of his filings, his briefings in the Jack Smith case. And we got a demand now from the House Judiciary Committee Chair Jim Jordan saying, you're going to come in here and you're going to testify before our committee. We got the full announcement here from Jim Jordan's website. Of course, the Judiciary Committee, a very powerful committee in the House of Representatives, saying today, House Judiciary Committee Chairman Jim Jordan subpoenaed Thomas Windham for a deposition on Jack Smith's team, high up in the team, regarding his role on Jack Smith's team after Windham refused to answer requests for a voluntary interview. We tried to play nice, Thomas, but now we're not. During Windham's transcribed interview with the committee, he relied on an unreasonably narrow interpretation of the DOJ's testimonial authorization to decline to answer questions about anything. He said, nope, I've got testimonial authorization, blah, blah. So he's like not invoking the fifth, he's invoking some other, with the House rules, testimonial privileges. Windham, so he's not answering. Windham's also refused to provide certain details about the other prosecutors he worked with during his investigation into Trump, citing the lack of specific department authorization. Okay, well, tell us about the other people you worked with. I can't talk about it. Department rules. What department rules? Says Congress. These positions are in direct conflict with the department's clear direction to provide unrestricted testimony. He's like, department policy says I can't. It's like, what? Our manual says you have to provide unrestricted testimony. Now, Windham also relied on an overbroad interpretation of federal rules of criminal procedure to answer questions about his interactions with the FBI to get billing records from the Willard Hotel. Oh, what was he doing at the Willard Hotel? His knowledge of a potential FBI investigative matter into Trump and individuals within his orbit, and communications within the partisan J6 fake illegally constituted select committee. This position is unsupported by federal court rulings and thus does not create a legitimate basis to refuse anything. And so we've got jurisdiction to oversee this. And so we're going to. And we send him a subpoena. And here's what it looks like. Dear Thomas Windham, former senior assistant special counsel to Jack Smith. He's got lawyers lawyered up in D.C. Jim Jordan says, all right, dear Mr. Windham, on April 7th, the committee requested your voluntary cooperation with our oversight. You didn't do that. You were asked to testify about your role on Jack Smith's team. On June 12th, you came in here. During your transcribed interview, you declined to answer multiple questions on the basis that the department didn't authorize you to talk about those things. You also declined to answer based on rules of criminal procedure, but we're not persuaded by anything that you said. And due to your refusal to answer these, we were here voluntarily. We have now decided to issue compulsory process to obtain your testimony about these matters. Now, your refusal to provide testimony based on the department's letter is completely unfounded. Now, our letter requested your testimony. We had questions about your role as a prosecutor on Jack's team. We provided a non-exhaustive list of examples of misconduct by your office, and we're examining it. Now, the committee's request did not limit the scope of information, and as an accommodation to you, on 3 occasions, we even gave your attorneys topics that we thought that we were going to ask you about so you could prepare. Now, despite these accommodations and trying to help, so much for that, and efforts to ensure that you provided a comprehensive testimony, you still declined to answer questions on the basis that the DOJ had not authorized your testimony. Now, your reasoning is unpersuasive. First of all, authorization from an executive branch entities are not necessary when you're testifying before Congress. And we're not aware of any such constitutional or statutory requirement, and you have offered none, conditioning your cooperation with express permission from a former employer. You're not even there anymore. Such a requirement would contravene separation of powers and restrict the ability to conduct oversight. It's like, I can't talk about it. My boss has said I can't. Congress is like, all right, guess this hearing's over. However, even assuming the department is required to authorize your testimony, it already did. In an email dated on May 29th, 2 weeks before you came in to talk, but not talk, the department provided your attorney with the scope of our questions, including 4 broad topics and 20 subtopics. On June 4th, we also consolidated and organized these into 5 topics, granted you specific written authorization in writing to provide unrestricted testimony, irrespective of privilege, on these topics. The DOJ says, you got the green light from us, bro. Talk. Rather than raise concerns or seek clarification about any of this, your attorney chose to lodge unfounded and conspiracy conspiratorial accusations and amorphous conflicts of interest that allegedly prevented the department from properly authorizing your testimony. Okay, so they're saying, oh, no, that letter is from a Trump hack person. Well, it's authorizing you. We control the DOJ now. No, not really, though. I'm following the old guy's rules because your new guy's illegitimate, is what they're saying. So during your transcribed interview, you relied on unreasonably narrow interpretations of testimonial authorizations. And we got a lot of questions for you. J6 Committee, Fulton County District Attorney's Office. That's Fannie Willis. The National Archives. That's Deborah Stidel Wall. And the U.S. Postal Service. Now, in addition, you invoked an absurd and indefensible interpretation of the department's authorization, saying, I can't talk about any of this because FBI officials are not included in DOJ officials, and so they're outside. You said I could talk about DOJ stuff, not the FBI, and the FBI did a bunch of stuff, so I can't talk about them. Now, this position is nonsensical. You know, the FBI is a component of the DOJ, and the department specifically informed your attorney that the committee would inquire about communications with FBI officials. Finally, so don't pretend like it's a different agency that is not related. It's under the DOJ. Finally, you refused to provide certain details, including names, about other prosecutors you worked with during your investigation into Trump. These positions are in direct conflict with the demand from the DOJ to provide unrestricted testimony. So then next, you turn to the federal rules of criminal procedure and you say, well, the grand jury proceedings. And so, wild. You adopted an expansive interpretation of Rule 6E. You said, I can't answer any questions about the J6 committee. I can't answer any questions about the FBI or Willard Hotel. And I'm curious what that hotel is all about. The Windham interview. So was he doing something there? Were they all hanging out, having little freak off parties up there with Jack Smith and Molly Highlighter Gal on the J6 case? I don't know what's going on over there, but it's interesting. And they spent a lot of money, like $100 million as by some estimates over the many years, which is crazy to think about. That's our money used to prosecute our candidate who won. Federal courts have been clear that 6E does not require that a veil of secrecy be drawn over all matters in the world that happen to be investigated by a grand jury. He's like, well, this could appear in front of a grand jury, and so I can't talk about any evidence that might appear in front of a grand jury. He's like, oh my gosh. The mere fact that information has been presented to a grand jury doesn't permit you to withhold it. Documents and testimony created for an independent purpose, because everybody could basically say that for everything, right? Well, you're asking me questions because something might happen legally, so I can't talk about that. Are you invoking your right to remain silent under the Fifth Amendment? No, you're not. Okay, so what are these other rationales for not answering the question? These rationales. Okay, well, those don't apply. We just took those out one by one. Well, I guess now I can't talk about it because you're investigating something and it might end up in a grand jury somewhere. We're like, well, that's why we're asking you questions. So again, are you invoking your right to remain silent under the Fifth Amendment, or are you just saying that, because that's not exactly what he's doing right now. He's trying to find other reasons, right? It's a grand jury in front of a grand jury. Okay, well, that's not a valid basis because everybody could invoke that for everything, right? Nobody could ask anybody any questions ever because everybody would just say, sounds like you're investigating something. So it's not related even to the prospect of a grand jury, and this does not even constitute a matter before a grand jury, and this is Congress. Congress is not prosecuting anybody. So quite simply, there is no per se rule against disclosure just because of the fact that some information might reach the grand jury chambers. And so here we got some good questions. Let's check on this hotel. Now, during your transcribed interview, you relied on Rule 6E, grand jury stuff, to shield or deny the committee information that's not even implicated by that rule. For example, you declined to answer questions about your knowledge of a February 2021 proposal that J.P. Cooney brought to the FBI to investigate President Trump and the individuals within his orbit on the ground that Rule 6E covers all matters in the course of an investigation, okay? So some other hack prosecutor says, I got this strategy to go after Trump right after they shoved Joe Biden in there. However, and he says, I can't talk about it because they were talking about something that might have led to a grand jury proceeding with Trump, and so I can't talk about it, Rule 6E. They say the committee specifically caveated your question. We said, okay, fine. Don't talk about anything you learned from a grand jury. And your personal knowledge of the matter does not constitute a matter before a grand jury, right? You're not sharing other evidence that other people are presenting to them. We're asking about your personal knowledge and what you saw. And if you want to say it came from a grand jury, just don't tell us that information, but tell us the other stuff. He didn't. Now, you declined to answer questions about your interactions with FBI officials related to potential evidence in the possession of Willard Hotel. So it doesn't sound like a freak off. Our questions on this topic related to your general knowledge and interactions with department officials, including Stephen D'Antuono, about obtaining this material, which is also curious because Stephen D'Antuono was the same dude who said that the cell phone data was corrupted on January 6th. Remember that? All of it for the pipe bomber. all of the cell companies corrupted their data. Nobody could find anything on this dude. Your discussions with department officials and your general knowledge of potential evidence aren't 6E protected. Now, your counsel also advised you against testifying about communications between Jack Smith's office and the partisan, illegally constituted January 6th Select Committee, asserting, well, 6E, those were for the purposes of an investigation. But that was not a matter before a grand jury as the rule requires. That was a fake committee. There's no serious argument here that any of those interactions are covered by the rule. Now, because these and other similar questions do not seek to reveal anything about a grand jury, there's no legitimate basis for you to invoke this. The committee has conducted transcribed interviews with several other people. We've talked about many of these things without them invoking this rule. For example, J.P. Cooney came in and he testified that he had communication with staff on the select committee, obviously, about obtaining information because they were all working together. Liz Cheney and the J6 committee was like a congressional grand jury in a way filled with Democrats that were issuing subpoenas and exercising a tremendous amount of power basically to gobble up evidence outside of the traditional court system, outside of the traditional law enforcement limitations, using congressional subpoena to demand Steve Bannon come in and Peter Navarro come in. And then when they didn't, then prosecute them, charge them with crimes, right? It was extrajudicial tyranny that was allowed to happen in this country by an illegally constituted House committee, by the way. Remember, H.R. 503, the authorizing document that said that they are an actual committee, said that it had to have 5 Republicans on the committee. It didn't. They put 2 on there. And it said it should have minority, all these rules and requirements. They didn't follow any of it. So the whole committee was illegitimate. Steve Bannon and Peter Navarro were illegally prosecuted and imprisoned based on a fake committee. It's one of the greatest tragedies in justice, in our criminal justice system, that has not been rectified in modern history. And they're in the same category as the J6ers and many other peoples who are abused by this process. And so far as we've seen, there's been no accountability for any of that at all, even with Trump running the DOJ. Now, we got pardons and things like that, but where are the mass firings of the DOJ? Well, we've seen some of them. A lot of Jack Smith people actually got fired, and now they're getting subpoenas. And so we'll see. I would hope and expect that every single person who touched the Steve Bannon case or the J6 cases, and remember, we just won a court hearing on this where this, I think it was the FBI case, the Norm Eisen case. The FBI associates and their association lost, and now the information about who worked on the J6 cases can be sent back over to the DOJ, and I hope that there are major firings that happen, and anyone who touched Steve Bannon's case, anyone who touched Peter Navarro's case, anybody who touched the J6 cases should be gone. Everybody, janitors, top to bottom. The department also included a narrow exception regarding the disclosure of this information, and during this interview, you relied on this narrow exception. You vaguely said that potentially the protective order in the case, and maybe some possibly other orders, prohibited you from answering questions about the J6 committee. Without offering any specific reference to the court order, the committee is unable to assess independently whether your testimony would be covered by that order, and so it's insufficient. So pursuant to all these rules, you now have a subpoena. Your voluntary cooperation was not complied with, and your refusal to answer questions are not persuasive. And so we're going to see your booty here at a deposition. You are being compelled to appear on September 30th. Gosh, at 10 a.m. That's a long time. Is your calendar full? You didn't have any dates in August? So that's a nice subpoena. We'll see what Thomas Windham has to say. Now, the next step I would expect would be to invoke the right to the Fifth Amendment, right against self-incrimination. We'll see if he does that when it comes time in September. But Jim Jordan was out making the rounds, hopped on a couple shows. And in this exchange, he was not talking specifically about this election and 2021, more specifically about and Jack Smith and the coup that was attempted there to try to take out their political opponent. But he goes back even further, all the way back to 2016, right? And a lot of this is just related. We're just following the bouncing ball from one up to another, all of them with the backbone and the intention of stopping Trump. Here's Jim Jordan.
The former president used the term updated guidance. I think that's a fancy way of saying we changed the story and we did it for political reasons, because that's what it looks like. Never forget, there's 3 key dates here, Maria. December 9th is when they had this meeting in the White House. Clapper, Brennan, McCabe. Comey, the president, they're all there, and they say, okay, we're not going to accept the intelligence community assessment. We're going to change that. And President Obama was just alluding to that. And then you have the date January 3rd. A few weeks later, Chuck Schumer goes on one of the Sunday shows and says, talking about then President-elect Trump, he says, if you mess with the intelligence community, they have 6 ways from Sunday at getting back at you. And then 3 days later, January 6th, they all go up to Trump Tower to give President Trump what he believes is his incoming defensive briefing as the new, as the president-elect. He thinks he's getting the normal defensive briefing. Instead, it's a setup. They go up there and talk to him about this, and then Comey tells him about the dossier that they already know is baloney. They know it's not true, came from the Clinton campaign and everything else, but they brief him on it so that when that information gets leaked, it has added credibility, because now it was so important that the FBI talked to the president-elect, the press has got to report it, and off and running goes the Russia collusion false narrative for the next 2 years. It was all to undermine President Trump and his presidency, and God bless Tulsi for sending this to the DOJ. I hope they dig into this. I hope that they go after this, because I think this is what it was, a conspiracy to undermine the first term of President Trump.
Exactly right. And it continued on. It was not just the first term. Once they failed on that first term, then they executed another operation and another operation and another. And we're still in the middle of it right now. Might be in the thick of it with this Epstein battle now that Pencil Neck Schiff is coming out saying, we need the documents. So it's a very interesting thing that's happening. Of course, Jim Jordan, we appreciate the subpoena. We've got a lot of questions about Jack Smith, who's not even a real boy and not a legitimate prosecutor who was ever properly appointed to this position. We had a good update. We'll see what happens with Thomas Windham, and we'll mark that on our calendars. September 30th, Thomas Windham getting his booty dragged into Congress. And if he doesn't show up and comply, he should be referred to the DOJ for criminal prosecution, just like Congress did with Bannon and Navarro.